Welcome back to another episode of Law Schoolers. We are continuing our discussion of criminal procedure, continuing our discussion about arrests and kind of distinguishing arrests and citations as well. Today's episode is going to be about those citations. Not too much to cover with citations, actually. We only have our rule plus a case to discuss it. But a citation is also known as an appearance ticket. This is an alternative to arrests. Your classic example of a citation is going to be your traffic citations. The idea is that when the subject is going to commit a minor offense, the officer can simply give a citation instead of conducting a full arrest. Several purposes for doing so. First is that the offense is going to be minor, and so the subject is likely to appear in court instead of trying to avoid in court. And the second main reason is that it saves the officer a significant time because they don't need to book and post bail for every single minor charge that they are doing, or they don't even need to get an arrest warrant to conduct citations as well. There is a third reason as well. The third reason is going to be citations help keeps the jail system under control because we will have less people waiting to be booked for minor offenses. So what's our case here? We've got one case at State versus Bayard. Essentially, to have a valid discretional arrest, here's our rule. Based on state constitutional grounds, because this is a state case, the officer's discretion must be reasonable, as shown through probable cause and a need for the arrest. In State versus Bayard, the type of arrest that occurred here was fine underneath the federal constitution, because you have a case called Atwater versus City of Largo Vista. The federal rule is that an arrest for even a minor offense is constitutionally permissible if there is probable cause that the crime was committed. However, states are free to limit that discretionary power of officers through state legislation. In Nevada, the place where this had happened, the legislation and the court interpreted the statute to mean that an arrest cannot occur for minor offenses, and instead a citation should be given if there's no reason to conduct the arrest for such a minor violation. In this case, the defendant committed a minor violation. There is no evidence that the defendant would skip out on court because of this. He did not appear to be a threat of committing any other crimes. And so the officer should have given a citation instead of conducting the defendant to a full arrest. And eventually what ended up happening is that it was this strip search as the defendant was being booked. Typically, when a full arrest occurs, officers can conduct a search. Just want to say that as a side note. That's something called search incident to arrest. We will be talking about search incident to arrest in a future episode if we haven't talked about it already. I don't think we have talked about search incident to arrest. We may have, but I don't think we have. We'll see. That might be later. I'll let you know. I think that's everything as far as citations go. Essentially what it is if you're conducting a minor offense, constitutionally you can do an arrest for even minor offenses, but states are free to limit that even more, and that's what happened here in State versus Bayard, saying it for minor offenses, what you should do is that you should give citations instead of going through the whole arrest system. Let me just search my notes real quick, see if I can find something about search incident to arrest to see if that's something we talked about previously or if that's something that is coming up. That is actually going to be in 2 episodes from now when we're talking about searches in recurring contexts, specifically searches of persons in recurring contexts. So I was right. It's coming up in a bit. And that's all we will talk about for citations, and I will see you in the next episode. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.